All right, in the matter of the people of the state of Michigan versus Kirk Anthony Smith, we have two files. We have file number 21-20601 DC or FC and 21-20602 FC. I have David Goldstein appearing on behalf of Mr. Smith, and Mr. Hartung, you're the prosecutor on that?
Actually, Ms. Wise is, but for purposes today, Mr. Hartung, I'm sure can.
I consider.
And there was an agreement to adjourn today's that didn't get processed in time. So how far out would you like a pretrial on this, Mr. Goldstein?
Your Honor, I think the date we talked about was December the 14th. I believe Ms. Wise is going to be gone for the rest of the month, so we wanted to get it done in December.
Okay, you'll do that. You're working on the stipping order for that?
Yes, Your Honor. Yes, Your Honor.
Okay, so we'll move that to December 14th at 8:30. And that takes care of that. All right, so then the only other one you have is Dillard, and we're waiting for him from the jail. So Mr. Erie,
Morning, Your
you have
Honor.
Mr. Nowak with you.
Yes, Your Honor. I wondered if it might be possible to put Mr. Fleming and myself in a room to talk for a moment.
I don't typically give breakout rooms with prosecutors or clients on a Wednesday morning because I usually need that prosecutor, but Mr. Fleming, do you have a moment?
Yeah, absolutely, Judge. No problem.
All right, so I would just say I may need him on my next case, so
I promise I'll be fast.
Minutes.
Okay, thank you, Judge. I appreciate that.
Not a problem. Just the volume we have doesn't allow for it, really. Okay. So I have Mr. Daly. Mr. Daly, do you have your client with you, Mr. Daly?
No, I think she's zooming in from home, Judge.
Okay,
I
she
just
hasn't
need to
done
set
it
a
yet,
trial.
so.
I just need to set
Okay.
a trial date. That's all we need to do.
Okay. We'll wait till she logs in. All right, so that's only a defense turn. Miss Adams or Miss McGrain, could you possibly text Mr. Murphy and let him know that I do have Miss McKay, right? Yes. In the courtroom, if he wants to just pop over and do that one really quickly.
Okay.
Thank you. All right, I have somebody who's logged on and their screen name is James H. Could I ask your last name, please?
Hilliard.
I'm sorry, say it again.
Hilliard. Hello? Can you hear me?
Yep, I couldn't hear you at first. Hilliard. Okay, got it. All right, I'm gonna type that in just so. Hilliard. Okay. All right. All right, so this is in the matter of, well, actually, that's not till, what is 8:30? Okay, so this is in the matter of Chloe M. Morris versus James Darnell Hilliard, file number 22-49582 PP. So, sir, this is the date and time set for a show cause for an alleged violation of a personal protection order. Sir, it states here that a PPO or personal protection order was signed by this court on June 8th of 2022, which remains in effect until June 8th of 2023. You were served with a copy of the personal protection order on July 7 of 2022. And the allegation is that you violated the personal protection order on August 5 of 2022 by sending mail or some communication to the petitioner in violation of the personal protection order. So do you understand those are the allegations against you, sir?
Yeah, can I go for a motion of discovery? Because I'd love to know what they're putting up against me. Because so far,
Okay. So,
it's basically
okay,
the
so
exact
sir,
same
hold on,
thing
hold
that's
on, hold
going
on,
on
hold
down
on.
here.
Because I don't want to talk about the case real quick, sir. I have a couple of questions for you and we'll get to that. So, Mr. Hilliard, the maximum penalty for violation of a personal protection order can be up to 93 days in jail and a $500 fine. Do you understand that? Do you understand that? Okay, now, do you understand that you do have a right to have an attorney represent you at this and all subsequent hearings? If you can't afford to hire one, we can appoint you one at public expense. Would you like to hire an attorney or would you like one appointed to represent you?
One appointed to represent me because I already have 4 of them down here.
4 attorneys?
Yeah.
I don't know what you're saying. So you want
Yes,
an
I'd like
attorney
a court-appointed
to represent you?
attorney.
Okay,
Yes.
you do want a court-appointed attorney.
Yes, ma'am.
Okay, so here's what I'm gonna do. I'm going to enter a plea of not guilty on your behalf. I'm going to appoint an attorney to represent you. Ms. Adams, I'm not gonna be able to do that today. So I'm going to set this over to November 30th at 8:30 in the morning.
November
And,
30th, 8:30 in the morning.
Yes, sir. So I'm going to set this for rearrangement with court-appointed counsel on November 30 at 8:30 in the morning. And you can call, you live in Laraway, don't you? I think you do.
I live in Virginia.
You live where?
I live in Virginia.
Okay. So, Ms. Adams, what is the telephone number for the public defender's office?
I don't think they have a general number. I can give you one of the secretaries over there.
Okay, so Mr. Hilliard, do you have something to write with?
Yes, ma'am.
Okay, so write this phone number down and it's gonna be the public defender's office. And then give them about probably till Monday or Tuesday, and give them a call. And then Ms. Weiss, I think you signed this personal protection order or warrant. Could you send a copy of the police report to the public defender's office? Somebody from the PD's or prosecutor's office?
I'm sorry, I couldn't unmute for some reason. What would you like? A copy of what police report?
Well, he's asking for a copy of the police report regarding the allegation against him for violation of personal protection order. And this is on Chloe Morris versus James Hilliard. File
Yes.
number 22-49582 PP. So could we get a copy of the police report over to the PD's office for him?
Yes, we can. Thank
We
you.
send it over to November 30th at 8:30 in the morning.
Okay,
And Ms. Adams, what is the phone number for the public defender's office?
Area code 517-264-5342.
All right, 517-264-5342.
Correct.
Yes, sir.
All righty.
All right, so Mr. Hilliard, I would probably wait till the beginning of next week and give them a call and they can email you any police report. That'll give it time to get there and we'll see you back on November 30th with your court-appointed counsel, okay?
All righty. When do I get the evidence that they have?
I just said the prosecutor will send the police report to the public defender's office and you can get it from them and they can email it to you,
All righty.
okay?
Yeah.
All right, thank you, Mr. Hilliard.
All right. Have a good day.
You too. All right, Mr. Erie, I pronounced your name right, did I?
Yes, so you're one of the few, Judge, but yes, you did.
Okay, all right, let me get, file, client. And this is in the matter of the people of the state of Michigan versus Christopher Matthew Nowak, file number 22-20795FH. This is the date and time set for a pretrial conference in this matter. I have Attorney Robert Erie appearing on behalf of the defendant, P26451. And I have Christopher Fleming appearing on behalf of the people. This is, as I said, the date and time set for a pretrial. Mr. Erie, how would you like to proceed?
Your Honor, the prosecutor and I have been talking, and there was some attempt yesterday to communicate as well. And we're discussing a potential plea. And so I think that the prosecutor and I have agreed to ask the court to set this for November 30th for a final pretrial.
That's correct, Judge. I was just discussing matters with them. The trial set for, it looked like the 13th of December. So if we can adjourn the final pretrial for the 30th, that'd be great.
All right, so we will continue the not guilty plea and we'll set this matter for pretrial on November 30 at 8:30 in the morning. And I think I have a scheduling order in here. So on that day, also jury instructions, voir dire questions, and any final motions are required. So if he's not going to plead that day, we need to have that stuff filed that day. All right.
Your Honor, I suppose it's not required, but I think in the interest of conscientious lawyering, if we don't reach a plea that day, we have an agreement with the prosecuting attorney, and I believe it was put on the record as well, that if an agreement is not reached, then we can remand it for preliminary exam. And so if we don't reach an agreement, I will be asking for that.
Well, what I would say is I expect you to do that before November 30th, because if you decide to go to trial and I don't have that paperwork by November 30th, it's in violation of my scheduling order. So if you don't reach an agreement, you can do a remand at any time.
Okay.
Mr. Fleming, we don't do remands unless there was.
I think this was prior to the rule being changed, Judge.
Okay. So at the time of the preliminary exam, you waive with the right to remand for preliminary exam? Because under the new court rules, I don't know if I'm supposed to do the prelim now or what.
Well, we can cross that bridge if we come to it, Judge. Let's try to see if we can get this resolved and go from there would be my suggestion.
All right, so we'll set this over to November 30th at 8:30 in the morning. And I'm just asking you to try to address all that before we get here. Thank you.
Absolutely.
Thank you, Mr. Erie. Thank you, Mr. Fleming. And you'll do the stip in order to adjourn. All right, Mr. Goldstein, I have a young man at the jail. What is your name, please?
William Dillard.
Good morning, Mr. Dillard. Let me grab your file. All right, this is in the matter of the people of the state of Michigan versus William Jarrett Dillard, file number 22-21069FC. I have Dave Goldstein appearing on behalf of Mr. Dillard, and I have Mr. Hartung appearing on behalf of the people. This is the date and time set for, is it arraignment or pretrial? Pretrial. So, Mr. Goldstein, how would you like to proceed today?
Well, Your Honor, since we anticipate setting this matter for trial, and since there are two other defendants, I'm assuming at some point there's going to be a motion to consolidate if it isn't already done. It might be productive to have all three counsel at the same time, other than we're going to be playing a game of ping pong back and forth on a trial date. So my suggestion might be, and maybe Mr. Hartung can weigh in, we just adjourn this a week or so and set up a conference with the council. I don't know where other counsel are this morning.
Okay.
Your Honor, the
go ahead,
other two.
Mr. Hartung.
Thank you. The other two attorneys, Mr. Maurer represents Mr. Tyndall. Mr. Friel represents Mr. Monroe. They have already agreed to consolidate the cases for trial. I didn't know if Mr. Goldstein had an objection to it or not, but those two had already weighed in. They signed a stip.
Yeah, okay, no, I was assuming it'd be consolidated, so.
So my suggestion
Okay.
would be, I was going to suggest this, since we don't have Sam Maurer or Brian Friel, I don't believe are in the waiting room at all.
No, Doug. Sorry, Doug. This is Dawn Van Dusen. I have Sam sick today. He's got really bad flu. So I'm on Tyndall.
Okay, so my suggestion was going to be that we set another date for a pretrial, but in that meantime period, let's have Miss Adams see if she can reach out and find some trial dates that all three of us can agree with, or all four of us actually can agree with. And I'm estimating 3 days for the trial.
I think that's probably
Okay.
fair.
All right, I don't have any trial dates for quite a while, so do you want me just to set a pretrial for, are you here January 4, Mr. Goldstein?
I would be available, yes.
Okay, I could set all three of them today for a January 4 pretrial. That would give you time to meet in advance if you need to, and then we could set a trial date that day, but I'm probably looking at April, May.
Your Honor, I'm
June.
gonna
And I know
suggest,
David Goldstein has a bunch of trials coming up, so it'd probably be summertime.
okay, Your Honor, again, I don't have a problem with adjourning the pretrial, but I would suggest that we set up maybe a Zoom conference with court and counsel to talk about trial dates. Try to do it on the record on the 4th.
Okay, I just got Brian Fry in, so Mr. Tyndall's in custody, and Brian, who is your defendant today?
Marcus Monroe.
Are they all in custody?
I believe he's
They're all in
in custody also, isn't he, Brian?
Everyone's
Yeah,
Okay. So, so we're still officially only on Dillard, but Mr. Fry and Miss Van Dusen, you have a co-defendant. And I believe there's been an agreement now to combine all the cases for trial. Since you're all here, I could probably set a pretrial and a trial date. So these are FC files, so they do take precedence to a certain extent. There's 3 attorneys. I'm going to say probably I need to set it for a week. So we can do a pretrial in January, and then Miss Adams, I'm looking for a 1-week jury trial. They are in custody, so if we have trials with people not in custody, it would bump those.
Okay.
Your Honor, just so the court knows, I'm scheduled to start a 2-week murder trial in Washtenaw County on January the 9th. Which means for the next 2 weeks, I would not be available.
Okay. So Miss Adams, February, I know March is probably not good. I'll be out of the country, and then April, May.
All right, so we have a 2-week trial on Christopher Maurer starting in January 24th. So and that's a FC as well.
Well, probably February, April, May, February, April.
Your
February
Honor,
and March. I'm not available February, March, Your Honor.
So we're going into April, May.
yeah, Your Honor, that's way too far out there for my client. We have witnesses, quite a few, and we're afraid we might lose
Ms.
them.
Van Dusen, those are the next available trial dates I have because nobody's pleading out. So I have like 4 trials every single week scheduled already.
Well, I think we need to maybe do a backup on one then, due to the fact that my client has, he has his due process right for a speedy trial, especially on this case. I'm going to ask that we set one close due to the fact that we have witnesses that may not become available if we set it out too far, and he is incarcerated
All
at
right,
this.
so Ms. Van Dusen, I can't do this yet because I haven't called your case and I don't have your client present. So this isn't gonna work. So I'm gonna set this over for a pretrial on January. My next available is January 4 at 8:30 in the morning. And I'll set all of them that day for a pretrial, and then we'll have to, actually, I can do it on a day other than a Wednesday if you'd like.
Well, Your Honor, again, I would suggest that we set up either a live or Zoom meeting off the record. I think it's gonna be easier to do it if we're not on the record, and just sit down and hammer it out. I'd be available anytime after about the 12th of December I can do a Zoom anytime. Physically, I can't come to Adrian until after the 12th of December.
I understand. All right, Miss Adams, can I get like a time, like maybe an hour to meet with Miss Van Duzen, Mr. Goldstein, and Mr. Fry after December 12th?
Okay. About December 16th at 2:30.
That would probably work. That would work for me, yeah.
Yeah, that'd be great.
Miss Van Duzen,
That'd be great, Your Honor.
Mr. Fry?
Yeah, that works for me, Your Honor. Thank you.
All right, so we'll set a bench conference 12/16, and you said 2:30, Miss Adams?
Yes.
At 2:30, that can be in person or it can be via Zoom. What do you want?
Your Honor, everybody else is in Adrian and I can come down that afternoon, so let's do it live.
Okay, so we'll do it in person. Okay, and at that time, all right, so Mr. Dillard, I'm gonna continue your not guilty plea today. And then we'll have a bench conference with your attorney and the other attorneys just to plan how we're gonna do this to get in for trial and so forth on December 16th at 2:30. And you won't be there that day, but because it's a bench conference, but at that time, we'll set your next pretrial and your trial date. All right, Mr. Dillard?
Yeah, all right.
All right, thank you, Mr. Dillard, and thank you, Mr. Goldstein. All right, so Mr. Fry and Ms. Van Duzen, your clients are my other two people in jail, so we'll have them. So it would be Mr. Tyndall and you said Marcus Monroe?
Yes, Your Honor.
Isn't that in front of Judge Olsaver?
They got transferred to your docket when the cases got combined, Your Honor.
All right, Miss Adams, so we're gonna need Mr. Tyndall next, and then Mr. Monroe from the jail. Okay. All right, so Ms. Van Duzen, yeah, I didn't want the record to get murky because I haven't called your case here, Mr. Price, so that'll work out better that way. All right, so I have in my waiting room, Ms. Brenner, I do not have Rhonda Underwood, so I don't know if you have anything in front of Judge Olsaver to do first.
We just did those, so I think she's headed this way. I don't know if she had any others with Judge Olsaver, but I did the two that I had with Olsaver, and I told her I'd see her over here. So hopefully she'll be here soon, Judge. Thank you.
All right. All right, I have somebody on a Stratus device. I don't know. Your face is dark, so I'm not sure who you are. I think it's a woman. There you go, blonde hair. What is your name, please?
Jennifer Webb, sorry.
All right, Miss Webb, thank you. Mr. Daly?
Alrighty.
All right, so this is in the matter of the people of the state of Michigan. Versus Jennifer Suzanne Webb, file number 22-21095FH. I have James Daly appearing on behalf of Miss Webb. And I have Isaac Sneed appearing on behalf of the people. This is the date and time set for a pretrial in this matter. Mr. Daly, how would you like to proceed? Mr. Daly, you're muted.
Just like to get a trial date set.
Okay, how many days are you looking for trial in this?
I believe 1 day.
1 day? All right.
Yes.
So let me look at something. Right, Ms. Webb is charged with 1 count of receiving and concealing property, which carries a maximum penalty of up to 5 years in prison. She's not in custody, so Ms. Adams, I'm looking for a 1 day trial date.
Okay. As a backup or the first available?
She's not in custody, so it could be a backup. Or towards the end of another trial, either is fine. But it can be after, it could be in March or February.
Thursday, March 16th would be day 3 of another jury trial.
Thursday, you said?
Yes.
All right, Mr. Daly, are you available March 15th?
16.
16th?
Yes, yes, Your Honor.
All right. All right, so we will set this for jury trial on March 16th of 2023 at 9 a.m. And I will set this for another pre-trial on February 1 at 8:30 in the morning. And let's see, so March, I'm going to require that all motions, voir dire questions, and jury instructions be provided and exchanged by March 3rd of 23. And anything else, Mr. Sneed or Mr. Daly?
No, thank you, Judge.
All right. Excellent. I pulled out a scheduling order and we will head out. Thank you both. Ms. Webb will
Thank you,
be back
Judge.
on March 1 at 8:30 in the morning, okay?
Thank you.
Thank you.
All right,
February 1.
Oh, it was February 1 is the pre-trial.
Right.
Sorry about that.
Right.
At 8:30 in the morning. All right, thank you.
Uh-huh.
All right,
Yeah.
I have someone, you can disconnect, Ms. Webb. I have someone who's logged in on an iPhone. I'm going to send you a request to unmute
Okay. Yep.
and start your video. Ms. Webb, I'll help you on your way.
Thank you. Yeah.
You're welcome. So I have someone who called in on an iPhone. What is your name, please?
Elizabeth Warner. Did you get that?
Yes, I did. All right,
Okay,
Ms.
sorry.
Warner, you are represented by Mr. Murphy, so I'm going to change your screen name.
Okay, thank you.
And I will put you in the waiting room. He appears in Judge Olsaver's court first. So if you want to call back in a half hour, you can, or I'm just going to put you in the waiting room.
Okay, I can call back in a half hour.
Okay, all right,
All
thank
right.
you.
No problem. Thank you.
Thank you. Okay, so who do I have joining me from the jail?
Skytion Tyndall.
All right, Mr. Tyndall, hold on 1 second. All right, and Ms. Van Dusen, you're appearing for Mr. Maurer today. So this is in the matter of the people of the state of Michigan versus Skyshun Deshaun Tyndall. We have multiple files, 20-20027 FH, 21-20675 FH, and 22-20717 FC. I have Dawn Van Duzen appearing on behalf of Mr. Tyndall today. Mr. Tyndall, Mr. Maurer is sick today and not able to be here. And I have Douglas Hartung appearing on behalf of the people. Ms. Van Duzen, on one of the co-defendants, we did set that matter for a bench conference on December 16th at 2:30 in the morning or afternoon, not the morning. So are you asking that this matter be scheduled for a bench conference on that same day as well?
Yes, Your Honor.
All right, so we will set a bench conference for December 16th at 2:30 in the afternoon. Mr. Tyndall, or I'm sorry, yeah, Mr. Tyndall, what that means is your attorney and the attorney of several of the co-defendants will be meeting with me to talk about how to set the trial and what to do going forward. You won't be present for that, but at that date, at that time, we will be setting a pretrial date and a trial date as well, and that will be communicated to you through your attorney, okay?
Okay.
And I'll continue your not guilty plea. Mr. Tyndall, do you have any questions?
Yeah, I was gonna ask Doug Hartung if it was possible if he could lower my bond so I could be out for Thanksgiving with my children then, if that's the case. If that's fine with you, Doug? Please?
So you're asking for a bond reduction?
Please, that's okay with Doug?
Well, it's actually the judge's call. We discussed this previously, Mr. Tyndall. And I think we did agree to have a bit of a bond reduction before at our previous hearings. I can't agree to do anything right now. But as always, I'm willing to sit down and talk to Mr. Maurer or Ms. Van Duzen, whoever's going to continue to represent you in this matter, about all kinds of different options in this matter. And I continue to pledge that I will do that. But at this point in time, I'm not agreeable to a bond reduction as we sit and talk today.
So Mr. Tyndall and Ms. Van Duzen will leave a note for Mr. Maurer to file a motion for a bond reduction.
All right.
And I get those in fairly quickly, so I schedule those in very quickly, all right?
All right.
All right, so your bond's continued at this time. Thank you, Mr. Tyndall. Thank you. All right, so let's see, I have Don Van Duzen. So Brian, who else do you have? You have,
I believe I only have Marcus Monroe with you, Your Honor.
okay, so we'll wait for him from the jail. I thought we had. Oh, yep, Marcus Monroe. Okay, so Keating Lance, do I have anybody in the courtroom that's represented by Sam Maurer? Okay, so I'm gonna start with the gentleman in the back. You want to come up to the podium? What is your name?
Michael Wilson.
Wilson?
Yeah.
Okay, Ms. Van Duzen, this would be Mr. Wilson. So let me find it on my docket. Okay, so this is in the matter of the people of the state of Michigan versus Michael J. Wilson, file number 20-19830FH. Sam Maurer does represent you, but he is out sick today.
Right.
And so Ms. Van Duzen is here on his behalf. I have Christopher Fleming appearing on behalf of the people. So this is a date and time set for pretrial. Ms. Van Duzen, how did you wish to proceed today on this?
Your Honor, at this time, he's going to plead not guilty. I asked do you have any dates like for next week on this? Because I'm kind of confused about his notes at this point, as in Mr. Mauler's, because it looks like he was just screened and accepted into
That's
veterans
what, hold
court.
on, Ms. Van Duzen. So I have a note in my file that you're a veteran. So were you screened for veterans court?
Yes, I'm actually the first veteran to ever.
I know, I'm super excited. So you were accepted into veterans court.
Yes, I am.
So, all right, so he's been accepted, so he'll need to plea at some point.
Yep.
To do that. And if you want us to have that done with, Judge Olsaver or myself, I can set that. I can put it in next Wednesday.
That'd be great, Your Honor. I just don't know what the plea offer is, and I guess if I talk to a prosecutor, we probably could get the plea done today. It's just a matter of, I don't know
Mr.
who the
Fleming,
prosecutor is in
What
it.
is the?
Yeah, I
plea
could talk
offer?
with Ms. Anderson real quick if I could, Judge. That'd be great.
Sure. All right, so Ms. Van Dusen, and okay, Miss. All right, so I'm gonna assign Miss Van Dusen and Mr. Fleming to a breakout room. Want to just have a seat? You can sit on the bench, you can sit at the table, it doesn't matter. All right, oh, I have. Miss Adams,
Yes.
would it be possible to contact Mr. Rains and Mr. Noe to see if they can come in at 1:30 today?
Okay, I will check.
Tell them that I probably will not be able to go till 4:30 today because we have our conference. So if they want to move it to 1:30 or 2:30, that would be great.
Okay.
All right, Ms. McKay, you want to come up to the podium? We do have Mr. Murphy. All right, good morning, Mr. Murphy. How are you?
Good morning. I'm doing good. Thank you.
All right, so I have Ms. McKay. So is it Takaya? Yes. Okay, so this is in the matter of the people of the state of Michigan versus Takaya McKay, file number 22-21047FH, and Matthew Murphy appearing on behalf of Ms. McKay. And I'm going to go with Isaac Sneed appearing on behalf of the people. This is a date and time set for a pretrial on this matter. Ms. McKay is present in person. Mr. Murphy, how do you wish to proceed with Ms. McKay today?
Your Honor, I would ask if we could set another pretrial on this matter. I have a copy of the transcript I've received. I wanted to file a motion. I just haven't had a chance to review it and prepare that motion. So if the prosecution would have no objection, I would ask for us to do that today. My office would prepare a stipulation order for that as well.
All right, any objection, Mr. Fleming? You're
No
on Ms.
objection,
McKay's
Judge.
case. All right, so my next available is January 4, and Ms. Adams, can I get a notice of hearing from Ms. McKay? So I'm going to continue your plea of not guilty. I'm going to set this over to January 4 at 8:30 in the morning. Obviously, Mr. Murphy, if you schedule a motion, it can be before that, or that day is fine. And then
Yes,
we'll
Your
get a notice of hearing from Ms. McKay. And do you want Zoom instructions too? Yes. All right, and Ms. Adams, could I get Zoom instructions for Ms. McKay too?
Okay.
All right, so if you want to have a seat over there, we'll get you a notice of hearing and some Zoom instructions. That way, if you want to just Zoom in, you can, okay? All right, thank you, Mr. Murphy. All right, I see Ms. Van Dusen and I see Mr. Fleming back. So Ms. Van Dusen, how do you wish to proceed today?
I would recommend that Mr. Wilson will plead guilty. He is accepted into the Veterans Court and he will plead to possession with a 7411 if he completes successfully the Veterans Court with the CW dismissed.
Okay, so plead guilty to count 1.
Yes.
Veterans Court, 7411 if successfully completes, and count 2 dismissed.
Correct.
That's
Wanna
correct,
step up
Judge.
to the podium? All right. So what that means is if you successfully complete probation in the sobriety court or the veterans court, it would be the guilty plea would be set aside. And your record would only ever show just a charge, but not a conviction.
Okay.
Okay, so want to raise your right hand? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
All right, sir, and can you put your hand down and can you state your full name for the record?
Michael J. Wilson.
All right, so Mr. Wilson, you've heard the statement of Ms. Van Duzen and the prosecutor's office. Is it your intention then today to plead guilty to count 1 controlled substance possession of methamphetamine, which carries a maximum penalty of up to 10 years in prison and or a $15,000 fine? Now, Ms. Van Duzen, the felony information in this file is from 2020, and it does list license sanctions, but do those still apply?
Not with 7411, Judge.
But otherwise, okay, so do you understand that there wouldn't be license sanctions because of the 7411?
What's that?
So typically on charges like this, if you plead guilty, you could have your license suspended.
Okay.
But because you're pleading under 7411, there would be no license.
Okay, so I can still get my license while in this program. Okay.
Yeah,
that
okay, unless you buy it. Okay. All right, are you satisfied with Mr. Maurer and then Ms. Van Duzen as your attorney today?
Yes, Your Honor.
Okay, and other than 7411 and Veterans Court, neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed a possible sentence with the court. Is that correct, Mr. Fleming?
That's correct, Judge.
Is that correct, Ms. Van Duzen?
That's correct.
Okay. So I'm gonna pause here for one moment because I do believe, who do I have from the jail?
Marcus Monroe.
All right, so I'm gonna skip over Mr. Fry to your case, because that will just take a second. I want to open up the jail, keep the jail room open. All right, so in the matter of the people of the state of Michigan versus Marcus DeAndre Monroe, file number 22-20886 FC, I have Brian Fry appearing on behalf of the defendant, and I have Douglas Hartung appearing on behalf of the people. This is the date and time set for a pretrial in this matter. Mr. Monroe, I did have a conversation with your attorney as well as the prosecutor in this case. Your case has been joined with 2 co-defendants, and so we need to determine a trial date and how we're going to proceed going forward. So we are going to be setting what is called a bench conference with all 3 defense attorneys as well as the prosecutor and myself to set up a trial schedule. Okay, and we're setting that for December 16th of this year at 2:30 p.m. Now, Mr. Monroe, you won't be present for that meeting, but Mr. Fry will communicate with you the scheduling that we come up with on that day. And then we'll set a pretrial conference and your trial date that day. Do you understand that, Mr. Monroe?
Yeah, I thought I had trial at the end of this month already scheduled.
You thought you what?
Already had trial for this month scheduled.
Let me see.
Here.
So I don't see, hold on.
Your Honor, I
Mr.
think
Fry?
Mr. Tyndall had a trial scheduled for the end of the month, and then the other co-defendants got combined. So I think, and I think Mr. Hartung was going to be on vacation, so I think that had gotten adjourned.
All right, so because we have 3 co-defendants, Mr. Monroe, Mr. Tyndall's trial date was taken off. So I'm gonna meet with your attorney on December 16th at 2:30 p.m. and the other attorneys and the prosecutor, and we'll do a scheduling order on that date, setting a pretrial and a trial date. And then Mr. Fry will communicate further with you on that. And do you have any questions, Mr. Monroe?
No.
Judge.
All right.
Yes. He was scheduled for jury on January 17th, if you want to cancel that on the record.
That's a different case. That's the other file.
Oh, okay, I'm sorry.
That's okay.
All right, so Mr. Monroe, that's a different file that you're actually set on trial with. And then Mr. Fry will probably address it that day as well, okay, when we come in for the bench conference, all right?
Yeah.
All right, thank you, Mr. Monroe, you're all set.
Your Honor.
Thank you, Mr. Fry. Okay, I'm sorry, so back on with Mr. Wilson. So, all right, so other than 7411 in Veterans Court, neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed any other possible sentence with the court. Is that correct, Mr. Fleming?
That's correct, Judge.
Ms. Van Duzen?
That's correct, Your Honor.
And Mr. Wilson, is that correct as far as you're
Yes,
aware?
ma'am.
Okay. If a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial and not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that?
Yes, Your Honor.
And Ms. Adams, I'm going to need a sentencing date from Stephanie Andrews. All right. Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yes, sir.
If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about the rights that I've given to you?
No, Your Honor.
So how do you wish to plead to the charge that on or about August 31st of 2019 in the village of Clinton in the county of Laraway, that you did commit the offense of possession of methamphetamine, guilty or not guilty? Okay. Has anyone made any threats or promises to you to induce you to plead guilty to this charge?
No, Your Honor.
And do you understand if I accept this plea, you'll be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that?
Yes, Your Honor.
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Ms. Van Duzen,
No, Your Honor.
Mr. Fleming?
No, Judge, thank you.
Has your attorney promised you any particular sentence or estimated what your sentence will be other than what was placed on
No,
record?
Your Honor.
Okay, and is it your own choice to plead guilty?
Yes, Your Honor.
All right, so Mr. Wilson, on August 31st of 2019, were you in the village of Clayton in the county of Laraway?
Yes, Your Honor.
And you came in contact, or you at that time had in your possession methamphetamine, is that correct?
Yes.
And where was it?
It was in a straw.
In your truck?
Yeah.
And you knew it was there?
Right.
And it was your methamphetamine?
Yes, it was dust on a straw. I mean, I know.
It was
yes,
methamphetamine?
Yes.
And you knew it was there and it was
Right.
yours? And you had no legal right to possess it, is that correct? Okay, are you satisfied, Mr. Fleming?
You are satisfied, Judge.
All right. Has the court complied with MCR 6.302 B, C, and D? Ms. Van Duzen?
Yes, Your Honor.
Mr. Fleming?
Yes, Judge.
All right, I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. This court has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them. So, sir, you've been screened and approved for Veterans Court. Judge Olsaber handles the Veterans Court. So you have a right to be sentenced by the judge that took the plea. But in this case, because you're going down to Veterans Court, do you waive your right to be sentenced by me so you can be sentenced by Judge Olsaber?
I'm really not sure on how all the veterans work that.
Say that again.
I thought that was like the whole reason I was getting switched over to veterans court was this charge.
So what I'm saying to you is you just took a plea in front of me, right? So under the law, you have a right to be sentenced where you would be sentenced into Veterans Court by the judge that took your plea. And because you were assigned to me, now we've got to assign you down to Judge Olsaver so you can be in Veterans Court. So what I'm asking you is, do you want to be sentenced by Judge Olsaver and supervised by him?
Yes.
Okay, so you're gonna waive your right to be sentenced by me and be sentenced by Judge Olsaver.
Yes, sir.
Okay, do you understand that now?
Yes, sir.
Okay, so, Ms. Adams, what would be the date for sentencing in front of Judge Olsaver?
It is December 22nd at 8:15 a.m.
Alright, so. Alright, so. Alright, December 22nd at 8:15. So, Mr. Wilson, do you want it to be in person?
Yeah.
Okay, so that'll be in person in front of Judge Olsaver. So you're gonna meet, you've already met with Sarah Teskey, right? Have you met with anybody from Veterans Court?
No, just Teresa.
Teresa Rubley, okay. So, Ms. Holly, I'm gonna send him across the hall this morning.
That's what I was gonna
All right,
ask.
so- Yeah, so Mr. Wilson, I'm gonna send you across the hall to check in. Tell me you just took a plea, that you're being admitted to Veterans Court. They're gonna give you instructions on how to proceed. I'll probably set up a couple interviews with you with Ms. Teskey, a packet of paperwork to fill out. When you do that, be truthful about your background and the events that occurred. And then you'll be back for sentencing on December 22nd at 8:15 in front of Judge Olsaver. So when you leave here, go straight across the hall and check in there. And just tell them you just entered a plea, and I think Ms. Teskey's here today. Ask to see Ms. Teskey, all right?
Yep.
All right, so remember, you're gonna be in the first courtroom on December 22nd at 8:15. All right? All right, thank you. Good luck.
Yes, thank you.
So what is your name?
Donald Rose.
What's your last name?
Rose, like the flower.
Like that one? Okay. Mr. Murphy?
Yes, Your Honor, I'm sorry, I thought Mr. Rose was actually in custody, but could he go in the hallway so I could talk with him in a breakout session?
Okay, do you want him to come over to your office?
If he wants to do that, that'll be fine with me. I just need to
So you
speak
can
with
do
him.
one of two things. You can use the device in the hallway to Zoom with Mr. Murphy, or you can walk across the street to his office. What would you prefer?
I can just walk across the street.
Do you know where his office is?
No, I'm not sure.
So, you know where the pretty courthouse is? Next door?
Yeah, but very close.
Yeah, so if you go to the corner here in Winter, cross over the old courthouse, on the opposite corner, on the other side of the old courthouse, I think the building says Annex and Public Defender's Office, he's right there.
Okay.
All right. And Miss Adams, I dismissed the contempt against Mr. Wilson, all right?
Okay.
Okay, what's your name?
That's real.
Friel? Okay, why don't you come up to the podium? All right, so this is in the matter of Madison Lynn Grinnell versus Donovan James Friel.
Yes, ma'am.
File number 22-49593 PP. So, sir, we are here on an order to show cause on a contempt proceeding for an alleged violation of a personal protection order. And it says here that on June 9th, court issued a personal protection order, which is in effect on June 9th of 2024, and you were served a copy of it on June 12th of 2022. The allegation is that you violated the personal protection order on September 9th by appearing, it's very general, workplace, residence, or something of that nature for the violation. Now, sir, a violation of a personal protection order carries a maximum penalty of up to 93 days in jail and a $500 fine. Now, you do have the right to have an attorney represent you at this and all subsequent hearings. If you can't afford to hire one, we will appoint you one at public expense. Would you like an attorney appointed to represent you?
Yes, ma'am. Can I have?
Before you do that, now that you've asked for an attorney, I'm gonna set this over to another day, and then you'll get to meet with the attorney.
Can I ask you something by chance too?
As long as you're not making any admissions.
No, I wanted to see if I could sit down with either like how you said that you do a probable cause and sit down with the prosecutor. Can I sit down with you two and show you everything that I have?
So no, so that would be ex parte communication because you don't have an attorney. And so it would have to be you and her and me, and that's a hearing that we would have to have in the courtroom. But by appointing you an attorney, you take all that information, you meet with that attorney, you provide it to them, and then we set it for another pretrial. And because of our schedule, let me see, I set the other one, I'm gonna set this one to that day too. I'm gonna set this over to November 30th at 8:30 in the morning. Ms. Adams, can I get a notice of hearing, Mr. Friel?
Okay, what, I apologize. What is his name?
This is the Donovan Friel. It's 22-49593 PP. And could you write the public defender's phone number on the notice form too?
Okay.
And so we'll give you the phone number for the public defender's office. They probably won't get the paperwork right away, so I would probably call Monday or Tuesday of next week. And then who issued this? Mr. Sneed or Mr. Fleming, could someone make sure that the police report for this case is sent over to the PD's office?
Yes, Judge.
Okay, can I ask one more thing? Can the prosecutor ask her to stop adding me on fake accounts? Because she added me.
That's something you got to talk to your attorney about, and your attorney will address, okay? And then, you know, you get a hearing, so you'll get your hearing, but we just have to go through the whole process, okay? Yeah, so she's gonna get you a notice of hearing, and let's see that. You can sit there. All right, so Mr. Rose went over to Mr. Murphy's office. I still have Ms. Van Duzen, so I still don't have Rhonda Underwood, Ms. Brenner. All right, Keegan Lance, Dennis Rose. No, Miss Van Duzen, I don't see who represents Mr. Herman, Matt Murphy, okay. Good. Luck.
I have Mr. Luck, Your Honor.
Okay, finally, I was going through my waiting room trying to find somebody you had. All right, let me let Mr. Luck in. And then Miss Adams from the jail, I'm ready on, yes, Maurer and Anderson. So Maurer and Anderson, I know I was, right, this PD number on there? Yes. All right, so we'll see you back on that day, all right?
Thank you, Your Honor.
You're welcome. All right, Mr. Luck, can you hear me?
Yes, Your Honor.
All right, so this is in the matter of the people of the state of Michigan versus Jacob Matthew Luck, file number 22-21000FH. Mr. Luck, Mr. Valero is out ill today, so we do have Ms. Van Duzen representing you today. This is the date and time set for a pre-trial, and then my prosecutor is Isaac Sneed. So, Ms. Van Duzen, how do you wish to proceed with Mr. Luck?
Your Honor, can I have a real quick?
Breakout with Mr. Luck.
Sure. Mr. Luck, I'm gonna put you in a breakout room with Ms. Van Duzen.
Sounds good.
Okay. So let me find her. There she is. And there's Mr. Luck. All right. Go ahead and join that breakout. Mr. Murphy,
Yes, Your Honor.
I have Mr. Herman. Do you want to take care of Mr. Oh, you got, oh, that was fast.
Yeah, we're ready to proceed on Mr. Rose, Your Honor.
Yeah, I just didn't think he'd make it over there that fast. All right, so we're back on the record in the matter of the people of the state of Michigan versus Donald Jack Rose, file number 22-20793FH. And Matthew Murphy appearing on behalf of Mr. Rose, and evidently have Mr. Alexander Bayonetto appearing on behalf of the people. This is the date and time set for a pretrial. Show the last plea offer was plea to count 1, dismiss count 2, as well as his 4th offense notice. So instead of being a life offense, if convicted, it would only be a 5-year felony. So Mr. Murphy, how do you wish to proceed on behalf of Mr. Rose?
Yes, Your Honor. At this time, the prosecution has added onto the offer that they would agree to no upfront jail for Mr. Rose in this matter. Mr. Rose does want to accept that offer. He wants to plead guilty to, again, 1 count of misdestruction of property, 1,000 to 20,000. Dismiss 2nd count, dismiss the habitual offender notice, and with no upfront jail.
All right. So Mr. Rose, is that correct, Mr. Bayonetto?
It is, Your Honor. The other count would be acknowledged just for the purposes of restitution, but everything else is correct.
Okay. Mr. Rose, you want to raise your right hand? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay, so Mr. Rose, can you state your full name for the record?
Donald Jack Rose.
Let me write this down. No subs. No upfront jail. All right, so Mr. Rose, you have heard the statement of your attorney and the prosecuting attorney. Is it your intention then to plead guilty to count 1, malicious destruction of personal property, 1,000 or more, but less than $20,000?
Yes, ma'am.
All right, and you understand the maximum penalty for that offense could be up to 5 years in prison and or a $10,000 fine, or 3 times the amount of destruction or injury, whichever is greater. In this case, the agreement would be that there would be no upfront jail. So you understand that?
Yes, ma'am.
All right, so other than the no upfront jail, neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed a possible sentence with the court. Is that correct, Mr. Murphy?
Yes, Your Honor.
Is that correct, Mr. Bayonetto?
Yes, Your Honor.
And Mr. Rose, is that correct as far as you're aware?
Yes, ma'am.
All right. If a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial. If the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial, not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. You understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial. Do you understand that?
Yes, ma'am.
All right. Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yes, ma'am.
If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. So do you have any questions about the rights that I've given to you?
No, ma'am.
All right. How do you wish to plead to the charge that on or about April 7th of 2021 in Woodstock Township in the county of Laraway that you did commit the offense of malicious destruction of personal property, 1,000 or more, but less than $20,000?
Guilty.
Okay. Has anyone made any threats or promises to you to induce you to plead guilty to this charge other than what was placed on the record?
No, ma'am.
You understand that if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea. Do you understand that?
Yes, ma'am.
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Mr. Murphy?
No, Your Honor.
Mr. Bayonetto?
No, Your Honor.
Other than what was placed on the record, Mr. Rose, has your attorney promised you any particular sentence or estimate of what your sentence will be?
No, ma'am.
Is it your own choice to plead guilty?
Yes, ma'am.
All right, so Mr. Rose, on April 7th of 2021, were you in Woodstock Township in the county of Michigan, or in the county of Laraway?
Yes, ma'am.
Okay, do you still live in Taylor?
No, ma'am.
Where do you live in Laraway County now?
No, ma'am.
Okay. All right, so Mr. Murphy, I'm gonna need an updated address and phone number for him. If you can get that from him today and send it to Becky, please.
That's it.
Yes, Your Honor. I have the address. I'll provide that. I didn't realize the court didn't.
Okay, so on that date and time, you were in Woodstock Township in the county of Laraway, is that correct?
Yes, ma'am.
Okay, and so at some time you came into contact with a golf cart that belonged to someone named Diane Cook, is that correct?
Yes, ma'am.
And you were with some people and you destroyed or damaged that golf cart, is that correct?
Yes, ma'am.
Okay, and would you agree the amount of destruction would have been of a value of over $1,000, but less than $20,000?
Yes, ma'am.
And you didn't have any right to damage that golf cart because it didn't belong to you, correct?
Yes, ma'am.
Okay, and then was there another golf cart belonging to somebody named Randy Gazarek?
Yeah, I believe there was several golf carts. I'm not sure.
All right.
The owners.
And you damaged those as well, is that correct?
Yes, ma'am.
What were you guys doing?
Honestly, we were just driving them around, but where we were at, it was kind of like a wooded area. So once we started driving, we realized like we were in the trees and stuff, and we had hit some trees and we couldn't really keep.
Well, that got out of control pretty quick, didn't it?
Yes, ma'am.
All right. Mr. Bayonetto, has court complied with MCR 6.302 B, C, and D?
It has, Your Honor.
Mr. Murphy?
Yes, Your Honor.
All right, I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. This court has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them. I'm going to refer this matter to the probation department for a pre-sentence investigation. I'm going to set this for sentencing on December 29th at 8:15 in the morning. So Mr. Rose, there is a Killebrew agreement that you will not serve any upfront jail. So you have a right to be present in person for sentencing, but you can also Zoom in for sentencing. So do you want to waive your right to be present in person and do it by Zoom, or do you want to come in person?
I would like to do it over Zoom because I live about 3 hours away.
Okay, so we'll schedule that via Zoom. Now, I'm going to put you in a breakout room with Miss Holly from the Michigan Department of Corrections. Miss Holly will give you further information on how you need to proceed going forward. It's very important that you make the appointments and you talk as needed with the probation department. And when you do, be truthful with them about your background and the events that occurred. You will be required to come in person probably for your interview because they have to do some other things, but they'll schedule that at a time, not today. So as I said, be truthful with them about your background, the events that occurred, and we'll see back here via Zoom on December 29th at 8:30 in the morning.
Okay.
And Mr. Murphy, I'm going to, well, Miss Holly, I mean, he's here locally. Do you want him to walk across the street and just check in at probation? Why don't you do that? Why don't you walk back to the courthouse? I know where you were. You get your steps in today and check into the probation department, okay?
Okay.
All right, and tell him you just entered a plea. So, all right, we're all set. We'll see you back on that day. Thank you.
Thank you, Your Honor.
Thank you. I don't see those. Okay. All right. Let's see. Who do I have from the jail?
Maurer.
Okay. All right. And I think we're still on Mr. Luck, Ms. Van Dusen. So we're back on the record in the matter of people of the state of Michigan versus Jacob Matthew Luck, file number 22-21000. FH. Ms. Van Dusen, I know that you're just filling in today, but if you had enough time to talk to Mr. Luck.
I did, Your Honor, but could I get a brief breakout with yourself and the prosecutor?
Not really, because I'm live on Zoom, but
Okay.
Hold on. All right, so I'm going to, let me see how we do this. I'm going to open a breakout room with Miss Adams. Is that Mr. Sneed? And Miss Van Dusen. There we go. And I'm going to take a recess. I'll go back in Miss Adams' office and talk to you.
Thank you.
All right. Y'all remember you're live on YouTube, so okay. Okay, so we are back on the record with Mr. Locke. So Ms. Van Duzen, you're asking for another pretrial date on Mr. Locke?
That's correct, Your Honor.
Mr. Locke. What page is he on, Sue?
Page 3.
Oh, page 3 at the top. Okay, so my next, can't do any more November 23rd. Can't really do any on the 30th. I could do December 7. Would that be enough time?
It will be, Your Honor. Thank you.
Okay. So we'll do December 7 at 8:30 in the morning for our next pretrial. You'll do this in order to adjourn, Ms. Van Dusen.
Yes, we will do that. Thank you.
All right, so Mr. Luck, we'll see you back via Zoom or in person if you need to on December 7th at 8:30 in the morning, all right?
All right, thank you.
Thank you.
Bye-bye.
Bye-bye. So let's see, Jill. Mr. Maurer, right?
Yes, ma'am.
Have your file. All right, this is in a matter of the people of the state of Michigan versus Christopher George Maurer, file number 21-20597FC. Mr. Maurer, today we have Dawn Van Dusen appearing on your behalf. Mr. Milaro is out ill, and I have Jacqueline Weiss appearing on behalf of the people. This is the date and time set for pre-trial. Let's see, do we have a trial date? We are set for a 2-week jury trial starting January 24th. Let's see, jury instructions, voir dire questions, and so motions should be filed and heard by January 11th. Ms. Van Dusen, how do you wish to proceed today?
Mr. Maurer is going to plead not guilty. We ask for another pretrial in 30 days, though.
We'll continue his not guilty plea. And as I said, he is set for trial.
Your Honor, I have a question. No offense, Ms. Van Dusen. Matt Murphy's my second lawyer. How come he's not representing me? He's right there.
Your Honor, I was going to say I can step in for Mr. Miller on this case. Just an update. That is what Mr. Miller was asking, was for 30 days. We are having some discussions with trying to find some experts in regards to matters. That's why he was asking for another 30-day adjournment or for another pretrial in 30 days. I guess that's pretty much all that we can do this morning at this time. So.
Okay, so trial is 124. I can do December 28 or January 4.
January 4th would work better for me.
Myself as well, please. Thank you.
Okay, so pretrial conference, January 4 at 8:30 in the morning. So Mr. Maurer, yeah, you have multiple files and you have different attorneys, so.
Yeah, no, I know that. I just seen him there. I thought it would be more proper.
So we'll see you back here on January 4 at 8:30 in the morning for a pretrial, okay?
Could I possibly get a 2-minute breakout with Mr. Murphy?
Yes, please, Your Honor.
Sure.
Thank you.
No, thank you. Let's see, Mr. Murphy. All right, 2 minutes. Okay.
Thank you.
All right, so Brenda and Brenner. Keegan Lance, I do have Keegan Lance. I'll probably get you out of here, Miss Brenner.
Great, thank you, Your Honor.
I did. All right, Mr. Lance, you want to go ahead and unmute your device and turn your video on, please?
Okay, is this good?
All right, yeah, perfect, thank you. All right, this is in the matter of the people of the state of Michigan versus Keegan Kyle Lance, file number 21-20269FH. I have Sarah K. Brenner appearing as Assistant Attorney General, and I have Rhonda Underwood appearing on behalf of Mr. Lance. Mr. Lance, did you get your fingerprints taken? I know I probably ask you this every time, but did you have your fingerprints taken? Would it have been by the Michigan State Police?
Yeah, at one point in time.
Okay, where did you have them taken at?
I'm sorry.
When you had the Michigan State Police take your fingerprints, where was that?
That was at the police station downtown here in Adrian.
In Adrian?
Yep.
Okay, so was that the time you were when you were first taken into custody for this?
Actually, I think they did take my fingerprints for this. Yeah, no. For this, they took fingerprints at the jail.
Okay, we will check on that.
The reason why I say it like that is
I wasn't frustrated with you.
Okay.
No.
Well, so far the questions have me nervous.
No, it's because fingerprints get taken and we don't get them. So my staff spends a lot of time hunting them down. All right, so this is the date and time set for a pretrial. Rhonda Underwood, how would you like to proceed today?
Your Honor, I've spoken to Mr. Lance and I've spoken to Ms. Brenner on this matter. And I believe, Your Honor, we have a resolution today with a delay plea. If Ms. Brenner would like to put the offer on the table, Your Honor.
Yes, Your Honor, it's my understanding the defendant's going to plead guilty as charged. We're going to ask that you give him an 11-month delay of sentence. During that time, he's to continue paying his child support each month as ordered and reduce his arrearages down to $8,000 or less for a reduction of the charge to an attempt. And if he pays the balance in full, then the charge would be reduced to a misdemeanor disorderly person. We would not be requesting any upfront jail at this time.
Okay. All right, so as I have it, is he's going to be pleading under a delayed sentence for 11 months. During that time period, he will pay as ordered. And if he pays in addition and reduces his balance to less than 8,000, 8,000 or less than 8,000?
8,000 or less, Your Honor.
Or less, then the charge would be reduced to attempted. If he pays the balance off in full, he'll be reduced to a disorderly, and there's an agreement to no upfront jail. Okay.
Correct.
All right. So
I do have a question. How much do I currently owe?
As of today, it's $13,952.69.
Oh, it's better than what it was.
Well,
Yes.
I would tell you, Mr. Lance, that sounds overwhelming even to me, but I have seen people pay it off. Like they have sold cars, they've gotten a second job. I mean, it's impressive, the people that have been able to pay it off in 11 months. You know, it's overwhelming, but it's impressive. People can pay it off. So
I know, I get that. I'm kind of stuck in a hole, you know, it's just with not trying to, you know, play the violin or, you know, come up with an excuse, but I do have a couple spine diseases I'm dealing with. So I'm stuck as a janitor. My bring home is maybe $1,000 a month and just kind of skimming through life. And I don't know what to do. I have applied for Lowe's.
So it's okay. You can go through this with your attorney and the probation department. Okay, so raise your right hand, please.
Sure. Okay.
Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I hope so. Yes.
Well, it's a yes or no, it's not a hope
Yeah.
so.
Yeah.
Okay. So, sir, you've heard the statement of your attorney, the prosecuting attorney. Is it your intention then to plead as charged to count 1, child support failing to pay, which carries a maximum penalty of up to 4 years in prison and or a $2,000 fine?
Well, I don't want either one of those. Yeah. Yeah.
So, Mr. Lance, this is a felony, so this isn't funny.
I know it's not, but humor is one of my.
Because I will tell you, if you don't comply and you violate probation, you could go to jail or prison. So you have to take this seriously. All right. Best case scenario, you make your monthly payments, and at the end of 5 years, you have a felony on your record and you don't do any jail or prison. You know, even better would be that you do what you can, find alternate work, have your family help you out, take a loan, and you pay this off, and it gets reduced to a disorderly. But when I ask you questions, I need yes, no, guilty, not maybe, I guess. So I'm
Sorry.
going to ask you again.
Okay.
You've heard the statement of your attorney in the press, the attorney general. Is it your intention to plead guilty to count 1, failure to pay child support, which carries a maximum penalty of up to 4 years in prison and or a fine? Yes, guilty or not? Is it your intention to plead guilty to that?
Yes.
Okay. Now, are you satisfied with your attorney and the advice that she has given you?
I don't really have any complaints. She's been
Now-
either. Go ahead.
No, finish. Go ahead.
I was gonna say she's been, polite and fair. I don't really have any complaints.
Excellent. All right. So neither the prosecutor, the defense attorney, or anyone on the defendant's behalf has discussed any other possible sentence with the court. Is that correct, Ms. Brenner?
That's correct.
Ms. Underwood?
That's correct, Your Honor.
And Mr. Lance, is that correct as far as you're aware?
Yeah.
Now, Mr. Lance, if a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. Close that breakout room. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial, not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that, Mr. Lance?
Yeah.
Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yeah.
If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about the rights that I've given to you?
Not really. You pretty much had told me I don't have any. So.
No, I explained the difference between your trial rights. If you were convicted at trial, you have an automatic right to appeal. The difference by entering a plea is that you have to file an application for leave to appeal. You don't have an automatic right. So you have plenty of rights, and we do ensure that your due process rights are protected. So do you understand the difference between trial rights and rights if you enter a plea?
Yeah. Yeah.
All right, sir, do you have any other questions about the rights that I've given to you?
No.
How do you wish to plead to the charge that during the time period of April 1 of 2018 through November 30 of 2019 in the county of Laraway and the city of Adrian, that you did commit the offense of child support failing to pay. Guilty or not guilty?
Too bad there's not an option for an explanation.
Okay,
So,
Mr. Lance.
I'm sorry, guilty.
Okay. Are you sure?
Yeah, I'm sure.
Okay. Has anyone made any threats or promises to you other than what was placed on the record to induce you to plead guilty to this charge?
No.
Do you understand if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea?
Yep.
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Ms. Brenner?
No, Your Honor.
Ms. Underwood?
No, Your Honor.
Other than what was placed on the record, Mr. Lance, has your attorney promised you any particular sentence or estimated what your sentence will be?
I mean, besides what we discussed, no.
Okay. Is it your own choice to plead guilty?
It is. I don't think I have a choice. But yes.
Well, you have a choice to go to trial or to enter the plea. I mean, those are your choices.
Yeah.
So is it your own choice to plead guilty?
Yes.
All right. So, Mr. Lance, you have a child with Calista Cecilia Moore. Is that correct?
Mm-hmm. Two of them, Logan and Lucas, 7 and 5.
Okay. And during the time period of April 1 of 2018 through November 30 of 2019, there was a child support order that was put in place by Laraway County. Is that correct?
Yes. But around that
You
time.
were ordered to pay child support to support those children to Calista. Is that correct?
Not exactly. Her and I had a mutual agreement of $400 a month, and then from what I'm aware of, she went to the court and found out she can get $750 a month for back pay of X amount of months to add it up to $16,000. She gave me a
Mr. Lance, I can't accept this plea, so I'm going to set this for jury trial. So I would assume this would be a one-day jury trial.
Yes, Your Honor.
Ms. Adams, I'm looking for 1 day.
Okay.
So what did I do wrong? I don't.
Well, you didn't put what you needed to on the record because you added a lot of excuses and you said that there wasn't a child support order. So I'm not accepting your plea. I'm going to set it for jury trial. You can speak with Ms. Underwood at a later date.
There was a
But
child.
I don't have time for this morning. This is my pre-trial morning. I have a lot of hearings and you seem to want to make a lot of excuses. So you can meet with Ms. Underwood and discuss this with her later, and I'll set another pre-trial. If you decide you want to plea at that time, that's fine. Otherwise, we'll go to jury trial. Ms. Adams, I'm looking for a one-day jury trial, please.
So we could do Wednesday, February 1st would be week 2 of a jury trial.
What day was that, Ms. Adams?
Wednesday, February 1st. That's on week 2 of a jury trial.
And that would be at 10:30?
Yes.
That's
correct.
fine.
Okay. All right.
That's
So I'm
fine.
gonna set this for trial on February 1 of 2023 at 10:30 in the morning. And I will set a pre-trial for January 4.
Your Honor, could we have it the next week? I'm off that week.
Yep,
Thank you.
January 11. January 11. January 11 of 2023 at 8:30 in the morning for pre-trial. I'm also going to require that by January 11, all Motion deadlines, or all motions must be heard. Jury instructions, about your questions are due. And today is 16th, all right? I filled out the scheduling order and I will get that out. Mr. Lance, I was a defense attorney for many years. Ms. Underwood does an excellent job. What I will say is you either take responsibility or you don't. But you still have a child support arrearage out there. So even though I'm adjourning it out, you should probably be making payments on it. If you have back issues, I suggest you get them treated and you find a part-time job in addition to your full-time job, or you apply for disability, one of the two. But we'll see you back here on January 11 of 2023 at 8:30 in the morning with the trial date scheduled for jury on February 1 of 23 at 10:30 in the morning. And we will mail that out to the parties. Thank you, Mr. Lance, you're all set. You may go.
Thank you, Your Honor.
Thank you. All right, Mr. Murphy, I don't have anybody in the jail window, but I don't know if I have anybody left at the jail. So I guess the only person I need from the jail is Caleb Anderson, because we already spoke with Mr. Maurer. And let's see, anybody in a breakout room? So I have Dennis Herman and I have somebody on an iPhone. That's her name is. Oh, and Miss Adams, I also forgot I still have Miss.
Judge, she's on the phone, so I don't think she's able to hear you.
I think she can, because she's magical. All right. Miss Warner, can you hear me? Mr. Herman, how are you?
Good. Yourself?
I'm good. All right, so this is in the matter of the people of the state of Michigan versus Dennis Allen Herman, file number 21-20576FH, and Matthew Murphy appearing on behalf of Mr. Herman. I have Isaac Sneed appearing on behalf of the people. This is date time, as I said, for pre-trial. I show a police report. Thank you, but I don't put the factual basis on the record. That would be either the prosecutor or the defense attorney. So, Mr. Murphy, how would you like to proceed with Mr. Herman today?
Your Honor, at this time, Mr. Herman wants to enter a no contest plea. Per the prosecution for Mr. Sneed's plea agreement, it will be a no contest plea to malicious destruction of property under 200. There will be agreement for no upfront jail on the case as well. I can establish the factual basis. I had sent that police report the other day just to try to expedite things. But obviously I'll put the factual basis on the record, or Mr. Sneed can, whatever the court prefers.
Okay, so he's going to plead to account 2 attempted or MDOP
No,
200
it's
to 1,000.
MDOP under 200 from my understanding.
Mr. Sneed?
That's accurate, Your Honor. There should be in the file the second amended felony information.
Do you know when that was filed?
It could have been late yesterday afternoon, Judge.
Oh, yes, I wouldn't have that yet.
I can email it now if you'd like.
Can you email it to me, Mr. Sneed?
I'll do so right now, Judge.
I can pull it up. Hold on, Mr. Herman, we'll be right with you.
Fine.
Can you include me
All right,
too?
who do I have at the jail, please?
Caleb Anderson.
All right. And well, Miss Van Dusen, would you like a breakout room with him?
No, Your Honor.
It's Caleb Anderson. You said yes, Miss Van Dusen?
No, Your Honor.
Oh, you don't? Okay.
Nope.
Okay, well, Mr. Anderson, sit down so I can see ya.
What?
Can you sit down so I can see your face?
I can't see you guys.
Oh, okay, I'm sorry. All right.
I'm blind, my bad.
It's okay. All right, matter of the people of the state of Michigan versus Caleb Michael John Anderson, file number 22-21127 FH. Mr. Maurer is the court-appointed attorney on this file, but he is out sick today, so we have Chief Assistant Public Defender Don Van Duzen appearing on your behalf, and I have Mr. Sneed appearing on behalf of the people. This is a date and time set for arraignment in this matter. Ms. Van Duzen, do you waive the reading of the felony information?
Yes, Your Honor.
And do you acknowledge receipt of the prosecutor's request for discovery and witness list?
I do, Your Honor.
And how do you wish to proceed today?
Mr. Anderson's
Going to plead not guilty, and we ask for a pretrial date.
Okay, so the court will enter a plea of not guilty on behalf of Mr. Anderson, and I will set this matter for pretrial on February 1 at 8:30 in the morning. And we'll see you back on that day, Mr. Anderson. Thank you.
All right.
Thank you.
Thank you.
Thank you, Ms. Van. All right, so let me check my email. Did you send that to me, Mr. Sneeder?
Judge, I just sent it to Becky and asked her to forward it to you. For some reason in our Outlook, your address doesn't pop up. So I have no idea why.
I blocked you. No, I'm just kidding. Ms. Adams, can you forward or print off or forward that to me?
Just sign it, Judge.
Okay. Oh, there it is. Okay. Hold on, Mr. Herman. Thank you, Mr. Sneed. I'm sure it's making its way across the hall. It just hasn't reached me yet. All right, so I have now received a second amended felony information, which has an added count 2 of larceny less than $200, which carries a maximum penalty of up to 93 days in jail and or a $500 fine, or 3 times the value of the property stolen, which is whatever is greater. So he's going to plead guilty to count 2, larceny less than 200. Count 1 will be dismissed, as well as the habitual offender third offense notice, and or he's going to plead no contest. And
Your Honor, I'm sorry. I don't have that information, but did you say larceny under 200? Because I thought it was to destruction of property under 200. And I don't know if I could establish a factual basis by the police report.
I think there's an MDOP under 200 charge, is there?
There is, and we'll have to submit an amended, Judge, and reviewing that. It's a mistake on that. So we'll get that prepared right now.
Okay, so it'll be an MDOP under 200, less than 200. So they'll provide another amended information, Mr. Murphy. Is that good?
Yes, Your Honor. Thank you. I didn't know how to establish for the larceny.
That's okay. All right, so he's in plead guilty. No contest.
I thought maybe.
Yeah, you're right. No contest. Okay, and so no contest, account 2, MDOP less than 200. I have notes like adjourning sentencing out for restitution, but that was maybe a prior plea. Are there any other terms to the plea, Mr. Murphy?
In regards to the matter, restitution, obviously, as I say with all my cases, that's, what's proven is the restitution is what Mr. Herman will pay. If there needs to be a hearing, I guess we can ask for that at the time of the sentencing if we disagree with what is placed in the PSI for the restitution.
Well, my question was, my notes say that I have sentencing can be adjourned to pay restitution before sentencing. Is that part of it?
That wasn't part of the plea to adjourn everything before, to pay it before sentencing. I don't know, was that something that you contained in there, Mr. Sneed? Because I didn't believe that was part of the
I
agreement.
have it in my notes. It doesn't
Oh,
matter.
okay.
It doesn't.
Okay. Sorry.
If I may state one thing on record, Judge, before we begin, the amount of restitution in the bill that was submitted is $1,255.47. So it's the people's expectation that is not going to be contested.
You understand that, Mr. Herman? Do you want to talk to me first before we proceed?
Yes, please.
Okay.
All right. Okay, so Mr. Herman, Mr. Murphy, just in the breakout room.
Deanna, do you have Deontay Sullivan on your schedule?
Let's see. Yep. Yes, I do. Do you have Deontay Sullivan with you?
No.
All right, so.
Is he in jail?
No,
Okay.
hold on. No. All right, so this is in the matter of the people of the state of Michigan versus Deontay Martez Sullivan, file number 2019-19746FH. Says the date and time set for pretrial. If Ms. Van Dusen appearing on behalf of Mr. Sullivan, and I have Mr. Fleming appearing on behalf of
Judge, we lost your video.
oh, I can turn that back on. So this is the date and time set for a final pretrial. Now, Mr. Sullivan showed up. Well, we had a pretrial November 3rd, and he didn't show up, but then he showed up later, and we handled it, I think, in the afternoon. So I quashed the bench warrant on that, but he is not here today. Is he at the PD's office?
No, he's not, Your Honor. They would have called me.
Okay, and this is set for trial on November 29th
That's correct.
of 22. Do you want to see if your office can reach out to him?
Yes, Your Honor.
Go ahead and take a moment and see if they can reach him,
Okay, thank you, Your Honor.
because otherwise I'd have to issue a bench warrant, take the trial date off. Okay. All right, Ms. Barrett. All right. This is in the matter of the people of the state of Michigan versus Samantha Jo Barrett, file number 19-19322FH, 22-20770FH, and 22-20769FH. So Ms. Barrett, we are here on a request and warrant for probation violation on each of these files. It is alleged on each of these files that on June 24th of 2022, you were ordered to comply with drug testing requirements. You failed to report for a drug screen at Laraway County testing on October 31, November 12th of 2022, and that on June 24th of 22, you were ordered to not use any controlled substances. And it is alleged that you tested positive for cocaine November 2nd, November 4th, November 7th, and November 10th, admitting to use of the same. Now, on file number 19-19322FH, you plead guilty or are found guilty of the violation of probation. The maximum penalty could be up to 5 years in prison. On file number 22-20770FH, Ms. Barrett, the maximum penalty on that file, if you plead guilty or found guilty, could be up to 1 year in jail. and loss of 7411. And then on file number 22-20769 FH, the maximum penalty on that file is up to 1 year in jail as well. And if you plead guilty or found guilty. So did I miss one? We got a 5-year. And then that's 1 year. 1 year. So you have 3 1 years. Oh, no, yeah, 2 1 years and 1 5-year. So Miss Barrett, those are the charges against you. Now you do have the right to have an attorney represent you here today and in all subsequent hearings. If you can't afford to hire one, we can appoint you one at public expense. Would you like a public defender appointed to represent you?
Yeah.
All right, Miss Underwood, are you available to speak with Miss Barrett this morning?
Yes, I am, Your Honor.
All right, so I will appoint the public defender's office to represent you. And I am going to assign.
I received the documentation, Your Honor.
Excellent. Thank you, Miss Underwood. All right, so you should receive an invitation to join the breakout room. Go ahead and do that. Okay, so I have Miss Warner, can you hear me? She is not connected to audio. I'm gonna pop the courtroom in the waiting room real quick.
I was down there about 10 o'clock. So I didn't see it. So
He's here.
I didn't see it.
Okay, so Ms. Van Duzen, were you able? Oh, Ms. Van Duzen, were you able to reach Mr. Sullivan?
No, Your Honor, but I just on Vine Link, it looks like he might be in Detroit, Wayne County Jail.
Are you able to ascertain maybe why?
Your Honor, I did just ask that if you'd like to put a bench warrant out at this time, and then I'll try to get notification up there if he is in one of their facilities.
Okay.
It looks like he has an ongoing case up there.
Okay, well, okay, so he was given notice on the record of today's hearing, as well as notice was provided to the public defender's office. Mr. Sullivan isn't here, may or may not be in the Wayne County Jail, but I'll issue a bench warrant for his arrest. And that way, at least we can get that holder on him in case something happens. So I'll set bond in the amount of 50,000 cash surety. And I will remove the trial date from our calendar for November 29th. And I'll make that a pre-trial at 9 a.m. just in case he shows up for that. You never know.
Okay. And I'll keep
So,
the court aware if I find out he is definitely in the Wayne County jail.
Okay, so we'll set November 29th as a 9 a.m. pre-trial. Miss Adams could email a notice out.
Okay, and you do have another jury trial at that time. I don't know if that matters.
No, doesn't. Okay. All right. Thank you, Miss Van Duzen.
Thank you, Your Honor.
All right, so I have, Miss Warner?
Yes, ma'am.
Okay, so Miss Warner, Mr. Murphy, let me see if I can get Miss.
I need to speak with Mr. Murphy if I could, please.
All right, hold on a minute.
Thank you.
second, I'm gonna get the jail back. All right, so, Mr. Murphy, I'm going to place you and Ms. Warner into a breakout room. All right. So, hold on. Where'd Mr. Oh. Okay. All right, so Miss Underwood, with regard to Miss Barrett, how would you like to proceed today?
Your Honor, I've spoken to Ms. Barrett. We've reviewed the allegations against her. And it's my belief, Your Honor, that Ms. Barrett wishes to accept responsibility and plead guilty to the violation today, Your Honor.
Ms. Barrett, you want to raise your right hand? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
All right, so Ms. Barrett, you can put your hand down, and then that room has kind of bad audio, so if you could just speak a little bit louder for me, okay?
Okay.
All right. So, Ms. Barrett, you've heard the statement of your attorney. Is it your intention to plead guilty to the violation of probations on each of these files?
If that's what I should do, I was trying to ask her if that's what I should do. That's all I wanted to ask her.
Oh,
Did you get
I
to
thought
ask
that's
her
what,
that?
I thought that's what you wanted to do.
That's what,
Samantha.
I mean, that's what I should do though, right? Because I mean, I am guilty.
I would not disagree with that assessment.
Okay. Then yeah.
Okay. All right, so Ms. Barrett, then your intention is to plead guilty to these violations today.
Yes.
Okay. Are you satisfied with Ms. Underwood as your attorney and the advice that she's given you?
Yes.
All right. Do you understand that you do have a right to contest the violation of probation charge and have a trial on it? Do you understand that?
Yes.
Okay, I'm going through your rights with you, Ms. Barrett. Do you understand that you would be presumed innocent until your guilt is proven by a preponderance of the evidence at that trial? Do you understand that?
Yes.
Do you have a right to have all the witnesses against you appear at your trial, to have your lawyer ask those witnesses questions, or you may ask them yourself, and to have me order any witnesses you might have to appear at the trial? Do you understand all of that?
Yes.
You do not have to testify at your trial, and no one can say anything about you not testifying or hold it against you in any way. Do you understand all of that?
Yes.
On the other hand, do you understand that you have a right to testify at your trial if you want to testify? Do you understand that?
Yes.
So Ms. Barrett, on each of these files, there are two violations. So violation one, how do you plead to the charge that you violated the terms of your probation by failing to report for drug screens on October 31 and November 12 of 2022? Guilty or not guilty?
Guilty.
And how do you plead to the charge on each of these files that you tested positive for cocaine on November 2nd, November 4, November 7th, and November 10, admitting to the use of the same? Guilty or not guilty?
Guilty.
All right, do you understand that by pleading guilty, you'll be giving up your right to a trial, as I've already explained to you?
Yes.
Has anything been promised to you to get you to plead guilty?
No.
Has anyone threatened you in any way to get you to plead guilty?
No.
If I accept this plea or these pleas, you will be giving up any claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea. Do you understand that?
Yes.
Is it your own choice to plead guilty?
Yes.
All right, so Ms. Barrett, one of the terms of your probation from June 24 of 2022 was that you were ordered to comply with drug testing requirements. Is that correct?
Yes, ma'am.
Now, were you supposed to report for drug testing on October 31 and November 12 of this year?
Yes, ma'am.
All right, and did you fail to report?
Yes, ma'am.
Okay. Now, you were also ordered not to use any controlled substances. Did you test positive for cocaine on November 2nd, November 4, November 7, and November 10 of 2022?
Yes, ma'am.
And you admitted to actually using cocaine, is that correct?
Yes, ma'am.
All right, Ms. Warner, I'm just gonna mute you for a moment. All right, so, and Ms. Barrett, you knew it was cocaine when you used it, correct?
Yes, ma'am.
Okay, I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of her rights. She does have competent counsel. That plea is accepted on each file. I'm going to refer this matter to the probation department for a pre-sentence investigation. I'm going to set this over to next week, November 23rd at 8 a.m. Would 8 a.m. be okay, Ms. Underwood?
I am off next week, Your Honor. But
Ms. Underwood, you can't take off if I'm not off.
I'm sorry.
I said you're my workhorse. You're here every day. You can't take off if I have to work.
I just told Miss Adams that I would not be here tomorrow morning, and but anyway, Your Honor, I believe since this is a sentencing, I believe someone could cover that, Your Honor.
All right. So Ms. Barrett, we'll have you over here for sentencing on the violation of probation next Wednesday morning at 8 a.m. Someone will be here to represent you. Do you have any objection to being sentenced via Zoom?
No.
Okay. When you meet with Ms. Teskey, be truthful about the events that occurred. She'll do a probation violation report. We'll see you back on just November 23rd at 8 a.m. All right.
When will I find out how long I got?
At sentencing. When I decide what you're gonna do.
Okay,
So we'll
so
see you
next
back in
week?
November. Next week, next Wednesday, we'll see you back.
Okay.
All right, thank you. Okay.
Your
Ms.
Honor,
Underwood, D'Angelo Williams, do you have him?
That is my case, Your Honor. Is he here?
No. Is he there?
No.
You want to try calling him?
I will try, Your Honor. He might have got this screwed up.
Okay. Why don't you
Hang
try
on.
to reach out to him? Okay. All right. So, Mr. Murphy, we're back with Mr. Herman. I think I'm done at the jail. Yeah, I think I can like all those jail windows. All right. So Mr. Murphy, you had a chance to talk to Mr. Herman. How would you like to proceed today with Mr. Herman?
Your Honor, I think Mr. Herman doesn't agree with the estimate amount, the restitution amount in this matter. I think that means that we can't enter a no contest plea per the prosecution's plea agreement at this time.
Well, he has a right to a hearing on restitution.
Well, that's what I wanted to happen, was to accept the plea and have a hearing on the restitution. But I think Mr. Snee was clear that the agreement was for an acceptance of the restitution amount. That was my understanding of it. I don't know. He would be willing to plead if we could have a hearing on the restitution.
Murphy, Mr. Sneed, he can request a restitution hearing, can he not?
Well, Judge, as part of the plea, he's not going to contest that restitution amount. If he's going to contest it, we might as well just have a trial on the felony.
All right, so Mr. Murphy, let me see here, hold on. So we are set for trial November 15th.
That was yesterday. That's the problem.
That was yesterday.
Yeah.
Okay, so, all right, so if there's no agreement for a restitution hearing, I can set it for another trial date or another pre-trial to review that with Mr. Herman. What would you like to do, Mr. Murphy?
Could we set up for another pre-trial, Your Honor, and see what can be figured out between now and then if Mr. Sneed doesn't object to that? Maybe
So
about
I'm gonna
another
set
month
it
from now or so.
For another pre-trial, I'm gonna set it for January 4 So Mr. Herman, I'm gonna set this over for a pre-trial conference on January 4 at 8:30 in the morning. So you zoom in like you did today, and Mr. Murphy, you do the stip in order to adjourn, correct?
Yes, Your Honor.
Okay, all right, so we'll see back on January 4 at 8:30 in the morning, Mr. Herman. Thank you.
All right, thank you. Thank you, Mr. Murphy.
Yeah, I'll give you a call later today. Okay, Mr. Herman?
All right, thank you.
Thanks.
Your Honor,
Yes.
as to Mr. Williams, the mailbox has not been set up. I would ask the court to consider a show cause, Your Honor, set this for a rearrangement or pre-trial, and we will try to get a hold of Mr. Williams.
Okay, you said you thought there was some mix-up or something, so you have some information that makes you believe there was a mix-up?
I don't have anything, Your Honor, at this
So
time.
do you want me to set it over to next Wednesday, and if you can get a hold of them, file a waiver? And if you can, I issue a bench warrant?
That's fine, Your Honor.
All right, and you can make Mr. Maurer cover.
Or
for you. All right.
the Wednesday after that would be even better.
Any objection, Mr. Sneed?
I'm
No,
sorry.
Okay, I'll set it over to November 30 at 8:30 in the morning. So November 30, and can you do that step in order to adjourn, Ms. Underwood?
I will.
All right, so we'll set it over, or no, that would be 8:15, I'm sorry, because it's an arraignment. So November 30 at 8:15. At your request.
Thank you, Your Honor. And if I don't see everyone, have a good holiday.
You too, thank you, Ms. Underwood. This one, okay, so I'm back with Ms. Warner. There we go. Mr. Murphy, I've got Ms. Warner. Now, Ms. Warner, go ahead and unmute your device. Ma'am, what are you here for?
Ryan, okay.
Okay. All right, so we're on the record in the matter of the people of the state of Michigan versus Elizabeth Jean Warner, file number 21-20607FH. Ms. Warner, why don't you go sit on that front bench over there? Or no, you, I'm sorry, ma'am, you go
I was
sit
like,
over there.
wow, how am I gonna do
No,
that?
not you. I'm sorry, I just used Ms. Warner's name. You have to sit over there. Yep. All right, so Mr. Murphy appearing on behalf of Ms. Warner, and you always amuse Mr. Fleming appearing on behalf of the people. So, Mr. Murphy, how do you wish to proceed with Ms. Warner?
Your Honor, in regards to Ms. Warner's case, there was a bond that was posted. I don't know if Your Honor recalls when there was issue with that bond. Ms. Warner has indicated to myself that the person who posted the bond and the bond was supposed to be released to pay for the restitution. She's been trying to get a hold of him. He's been taken into custody, and so she's trying to find a way to talk with the person and see if the person can update the court with the status as to whether or not they will allow, because Ms. Warner believes that the person does want the bond to be released. I was going to ask if the prosecution wouldn't object, if we could do one more pre-trial on this matter before setting a trial on this matter. If we can't get this figured out with the bond by the next pre-trial, Ms. Warner I've told her it has to be figured out. The money has to be figured out some way, if not from the bond. And so that's why I'm hoping for one more pre-trial, and then then if that's not figured out, then we could set a trial after that point. If the prosecution would object, then I guess we could set a trial at this time and try to get figured out before then.
So, Ms. Adams, all the notes in my file, we've had multiple phone calls by Mr. Irvin stating he does not consent to the bond being posted or turned over to the victim in this matter. Have there been any changes in that you're aware of, Ms. Adams?
I think Phyllis was handling that. Let me call her and ask.
That was the last I heard as well, Judge, that he refused to sign over the bond.
And then
Yeah,
I
Ms. Warner is
that he
indicating that
called and
since
wanted-
then, I think, was.
Okay, but he also
That-
called and wanted to know when his money would be written, so. Hold on, Mr. Adams is gonna verify that. Mr. Murphy, Mr. Rasco, Joel Rasco,
Yes, Your Honor.
is he over
He's
at
in
your
custody.
office?
He's in the jail.
Judge,
Yes,
He wanted the bond returned to him, so that's what was done.
All right, so Mr. Irvin. got
The
his
bond,
money
just to
back.
clarify, the bond was, money was returned to him already.
That
You know
is-
the date, can I find out what date that was?
Let me find out.
Ms. Adams, before you do that, can you let the jail know I need Joel or Rasco?
Okay.
They said he's in custody, but I don't show him on my jail list.
I thought he was in custody. I might be mistaken, but I think he's being held on. He has a pending case tomorrow, just being arraigned down in district on.
Judge, Mr. Rasco is in jail and they're gonna go get him now.
Awesome, thank you.
Your Honor, I guess in regards to Ms. Warner, if the prosecution would object to another pretrial, I'll ask for that. I guess I'm fairly ignorant of what's going on here. I need to figure something out with my client, and hopefully at the next pretrial date, we'll have that figured out, or we'll set a trial. Again, if the prosecution objects, I guess we can set a trial now and have it figured out before then.
All right, has there been a plea offer made in this file, Mr. Fleming?
There has been, Judge. It's to a misdemeanor, but that's upon payment of the $1,000 restitution up front. My concern, I don't necessarily have an objection really to the adjournment. My concern would be that there should be $1,000 bond still on Warner, and if that's not with the court, then technically she should be in custody. Would be my thoughts.
Judge, I did just get confirmation that was returned on September 29th, 22.
Okay. Okay.
Well, that's why the bond situation is really confusing, because, and of course, it was a while ago, and it was when it was still Judge Poor, because when I was looking through it, it seemed as though Judge Poor had changed the bond to a PR bond upon release of the money. That's why it was fairly confusing. But obviously, if the court wants to address bond this time in regards to whether or not there's an outstanding bond.
Okay. She's always appeared for court. She's been on time. I don't have any information that she's committed any new crimes. So I'll just let the PR bond sit. But what is the amount of restitution, Mr. Fleming?
It's $1,000, Judge.
So Ms. Warner, with that information, understand it, part of it was that money was to be released for restitution. So if you can raise that to pay the restitution, I think then the economics crimes unit would be involved in this case.
Yeah, so basically, I'm guessing this guy got over on me basically, because that.
Don't say anything more.
Ms. Warner, I wasn't talking to you. So Mr. Fleming, I have some notes. The rest economic crimes unit was involved in this. Is that true?
I think they were at some point, Judge. I don't know the status of that, to be honest with you.
Okay. All right. So what I'm going to do is set this for sentencing, or set this over for another pretrial on January 11. That'll give time for Mr. Murphy to talk to Ms. Warner, and that'll be January 11th at 8:30. And Mr. Murphy, you can do the stipend order to adjourn.
Yes, Your Honor.
that should be it. So we'll see you back on January 11th at 8:30, ma'am. Thank you.
Thank you, Your Honor.
Thank you.
I do have a new address though.
We are live on YouTube, so I'm gonna put you in a breakout room with Mr. Murphy or,
Ms. Warner, could you just, has your phone number changed? It
No.
hasn't changed. I'll just call you later after this morning, okay?
All right, thank you.
And I'll update the court with that address. Thank you.
Mhm.
or you, okay, all right, thank you. Or you can call, leave that message at the PD's office if you want for him, all right?
All right,
Thank you, Judge.
thank you.
Okay, thank you.
Bye.
Bye-bye. Okay. So, in the matter of the people of the state of Michigan versus Joel Jesus Rasco, file number 21-20645FH, I have Matthew Murphy appearing on behalf of Mr. Rasco, and I have Isaac Sneed, you're the last man standing, appearing on behalf of the prosecutor's office. This is the date and time set for rearrangement on a contempt. So, let's see. Contempt of court is for failure to appear for pretrial on August 10 and September 21 of 2022. What happened on the underlying files? Anything?
That's
yet?
still outstanding, Your Honor. We need to set another pretrial for that, and Mr. Roscoe has, there was another felony that happened since then that I think we waived the exam on, and now there's also another pending felony I just became aware of that he's being, we have a bond hearing on tomorrow, a new one down in district court. So in regards to this
When is-
contempt, obviously I'd ask to set it, continue not guilty plea on it, or enter and continue not guilty, set it for pretrial with the underlying charge. And I got to get an understanding of an offer from the prosecution in regards to all these cases that Mr. Roscoe has and get everything figured out.
Did you say he's already got one file up in circuit court as well as this one?
Yes, Your Honor, there's a, let me find the file number. I'm sorry.
I'm
I don't think I waived my preliminary.
That's,
Oh, I'm,
that's downstairs, Mr. Rasco. Did you say he has another felony file in circuit court than this one?
yes, let me,
And what's the pretrial on that one?
so the file that was, file 2120645-FH obstruction. It was set for pretrial. The last that we had was, it was set for pretrial on September 21st. That court date was missed and a bench warrant was issued, and we didn't have any further pretrial set after that.
That's for this case, right?
Yeah, that's for the obstruction for the alleged giving false information or false name.
I thought you said that he had waived another felony file upstairs.
I may have been mistaken. I mean, there was another felony. We didn't waive the exam yet. I'm sorry, Your Honor, on that one. We didn't waive that.
Okay, so I'm gonna set this for another pretrial on, I'll enter a not guilty plea on the contempt of court, and I'll set this for another pretrial on December 28th. And then maybe we'll have some information on those other files by then. So, Mr. Rasco, we'll see you back on December 28th at 8:30 in the morning on this file, okay?
Ma'am, I come back on
Could I have
29.
could I have a brief breakout session with Mr. Roscoe?
Hold on, Mr. Rasco, what were you gonna say?
I was gonna say about my other court date, but could I talk to my lawyer real fast?
Sure.
About my other court dates and all that real fast? I was just asking if I could get it a little bit sooner when I come back, like on the other days.
Well, yeah, I can move it to.
Well, Your Honor, could I just have a breakout with the session with him real quick, and I could probably just talk to him about the other court dates, and then if you wanted to move this one up, that's.
Hold on, I can move it to like December 7 or 14.
7th would be all right.
Whatever date is fine with me, Your Honor. It could fit in my schedule either way.
So Mr. Rasco, I'll move the date to December 7 at 8:30. All right?
I appreciate it, ma'am. I'm sorry for the inconvenience.
No, you're fine. All right, anything else on this file, Mr. Murphy?
Not on this file, Your Honor.
All right, so we'll see you back on that day, sir. Thank you.
Could I still have a breakout with my lawyer by chance?
Sure.
Thank you.
Mr. Murphy, do you have time?
Yep. Thank you.
All right.
I'm sorry.
So, hold on. All right, I'm gonna assign both of you to a breakout room. All right, there you go. Okay. So, see him anywhere?
Elton Holloway wasn't there. I texted down from the guys down in front to let me know if he gets in here. He's very responsive to that.
Okay. So, how do you pronounce your last name? Me? My last name Butler. Okay. You're just a witness?
Yeah, I'm just a friend of Ryan. You're asking me about Ryan, right?
Okay. All right, so this is in the matter of William Sidek versus Ryan Paul Laraway, file number 22-49672PH. This is the date and time scheduled for a show cause in this matter for contempt of a personal protection order. It was originally scheduled on October 26th of 2022 at 8:30 in the morning. It was adjourned to today. And Mr. Laraway was instructed to appear in person. We did receive a phone call stating that he was out of state, but we reiterated that the hearing was scheduled in person. And a notice of hearing was mailed out. I'm going to take the file back, but Mr. Laraway, as of right now, has failed to appear. I know that he was aware of the court hearings. He did communicate with my office, and he is not here. So I'm going to step off the bench for just a moment, and I'll be right back. All right, so I know that my office has had communication with him multiple times about today's hearing, and he has failed to appear. So I will issue a bench warrant for his arrest, and I'll set bond in the amount of 50,000 cash assured. All right, thanks everyone. That concludes our morning docket.
Your Honor, did we do a Caleb Anderson who was at the jail?
We did. He waived arraignment or waived the felony information, entered a plea of not guilty, and we set it for February 1 at 8:30 in the morning for pretrial. And I see nothing else. So
Thank you for the information, Judge. Have a good morning.
not a problem. Thank you all. know why they, like, I was kind of sad because they did like a water formation and then the starts boom.
Yeah.
Judge, you're still live on YouTube, just so you know.
I don't know how.
Everyone have a good morning. Thank you.